Hello and welcome. This is attorney Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices located in Nutley, Montclair, New Jersey. As you may or may not know, I do a weekly how-to video giving you some general advice about a certain topic of law. I also do daily tips and monthly webinars, which will also be posted on my website and my YouTube page. But this how-to series is kind of a bridge between the two of them. My daily tips, just a very short piece of advice to give you on a daily basis to help you with little things. My webinar is to go deeply into a broad topic. So the purpose of this is to give you a little bit of both, is to give you some substantive advice on a topic, but not something that you need to spend an hour listening to. So today's how-to series is what to do, or how to prepare, I guess I should say, for the receipt of either a settlement agreement or a judge's order or decision. You're both going to be very drastically different, but the most important thing to realize first is people think that you have no rights when you do a settlement. They think that you're waiving all your rights. You'll actually even answer questions suggesting that you know you're giving up all your rights. Not necessarily the case. With settlements, you still do have some rights for appeal issues. There may be certain motions that can be filed, and as much as I hate to say it, there are also malpractice issues in New Jersey that are recognized not only for your own attorney, but sometimes the other party's attorney may actually be liable to you for improper conduct. Not something I'm going to go into in depth in this video because it's far beyond the scope of it, but it's something to realize even with a settlement that there are certain rights. Now, with regard to receiving a court order or a judge's decision, there are several issues that you need to investigate and certain rights that you have. And it's really important that you investigate these before you actually receive the decision. Don't wait until you go into court and get a motion, or don't wait until you finish a settlement conversation to ask about these, because there are going to be certain time constraints that you're going to have, and there are going to be a lot of analysis that you need to do, and waiting until you actually get the decision may be too late. So the first thing you need to do when you get a decision or a court order is to find out about the legal rights to seek a reversal or a new decision. And these rights are going to vary greatly on whether or not the order is a final order or what's called an interlocutory or a temporary order. The difference is, now final means final, that there's no other issues or proceedings anticipated. And that's very important because many judges, in my experience, don't even fully understand when something is considered interlocutory, because anything that may follow the decision will keep it from being a final decision. So let me give an example. I had a case years ago now where we were opposing a person's request to relocate with their children. The judge granted the order and said, come back to mediate parenting time issues. So the issue about relocation was decided in final, but they had this future proceeding for mediation. I asked the judge on the record if this was a final order or not, because I was planning to appeal it. He said it was. I took it to the appellate division. They said it wasn't. And it's very important because the appellate division will do whatever they can to avoid deciding interlocutory issues. One, because they're not sure what the outcome is going to be. And two, everybody would be filing if you could file for any kind of temporary decision. So they're very, very rigid. It's an entirely different standard. It's a different time frame. So the first thing that you need to do is determine, is your decision or your court order a final decision or an interlocutory decision? Next, whether it's one or the other, you still will have similar rights. You can do first a motion for reconsideration. If you have a final order, the court rules require that you file a motion for reconsideration within 20 days. If you have an interlocutory decision, you can file a motion to reconsider at any time during the proceedings, as long as you're still before that judge or your case is still going. If you're going to file an appeal of a final decision, you have either 45 days to file it if it's a final decision, or 20 days if it's an interlocutory decision. So again, whether it's a motion to reconsider or an appeal that you're going to file, know what the time frames are and know what the differences are. If you do not file the appeal within the time frames set forth, the 45 days or the 20 days, you may be forever barred from seeking that relief. So it's very, very important that you understand these rights. And again, this is why I'm saying you need to do it in advance. Next, you need to decide if you're going to seek a stay of enforcement. That means obviously you're going to ask one of the courts to stop the effect of the order until the motion or the appeal is decided. Now, this is important because you need to do it at two different levels. You need to first ask the trial court or the judge that's assigned to your case to stay the order, and that may need to be done on the very day that you get to court. Another reason why you should be deciding these things in advance. If you get a decision in court after argument and you want to take it to an appeal, you should ask the judge then for a stay of enforcement. And if the judge refuses, which more often than not they do, you then need to ask the appellate division for a stay of enforcement, because they're not bound by the trial court's decision, but the appellate division will want to make sure that you first asked the trial court. So you need to know in advance of receiving this decision, again, whether you're going to be appealing it, whether or not you're going to need the enforcement or the stay of enforcement. And lastly, although I say this point for last, it's probably something you need to do much more earlier in your analysis, and that is figure out what the outcomes of all of these processes are going to be from a cost and advantage standpoint. First, you want to know the outcomes of your motion for reconsideration. Find out from an attorney, if you can, what powers the judge would actually have if he or she wanted to reconsider the decision. You also want to know what the appellate division is going to do. They only have so many options. They can either reverse the decision and change it. They can remand it, which means send it back to the trial court and ask for a new hearing or a new instruction or decision, or they can deny entirely and leave you where you started from. It's important to understand this, and I think also from a practical standpoint, you want to find out how long it's going to take to get to either of these outcomes, what the real benefit's going to be. Like, for instance, are successful in the appeal and you get a remand, you want to know what happens after the remand. Most likely it's going to be either a new hearing or a new trial, so you're starting over again. You may not be able to start over again. So you need to know beforehand what your outcome is going to be. You need to know that what you're filing for, whether it's a motion for reconsideration or an appeal, is actually going to bring you to a place where it's going to be helpful to move your case. It may take too long to decide. Like, for instance, the relocation issue I mentioned often takes a year or two for an appeal to be decided. Children are usually much older and their lives have progressed. Sometimes there are issues that between the time and the cost that even if you're successful in the appeal, you've spent more than you're actually fighting over. So you really want to do this analysis of the outcome and your cost probably in the very beginning. So that's it. Like I said, this is kind of in a nutshell what you want to do to prepare for receiving either a settlement, a judge's order, or a final decision in your matter. For more information on this and other tips, you can go to my website, which is micklinlawgroup.com. That's MICKLIN lawgroup.com. It's all one word. You can call us at 973-562-0100 if you'd like to schedule a consultation. And if you want more of these videos or constant updates, you can go either to my website, which will have them, or to my YouTube page, which is Brad Michael Micklin. Thank you.